We'll call the next case, which is Desmond Ricks versus the state of Michigan. This is a mini oral argument on the application. You each have 15 minutes. Ms. Patel, if you want to reserve, we want you to try and manage that yourself. You guys both know the drill quite well. You may proceed when you're ready, Ms. Patel.
Okay, thank you, Your Honor. Good morning, Your Honors. May it please the court, Sima Patel on behalf of plaintiff Mr. Desmond Ricks. Your Honor, we're here today because Mr. Ricks spent 25 years of his life in prison for a crime that all parties admit that he didn't commit. There is no question here that Mr. Ricks meets the eligibility criteria under the Wrongful Imprisonment Compensation Act, and in fact, he has been compensated under this act, but not fully. Mr. Ricks was denied compensation for 4 years and 118 days of his wrongful imprisonment. This is because Mr. Ricks was on parole at the time of the wrongful conviction. Now, by operation of Michigan statute, anytime a parolee is convicted of a subsequent crime, the time remaining on the first crime is tacked on and runs consecutive to the second conviction and sentence. Here, because Mr. Ricks was wrongfully convicted while he was on parole, the 4 years and 118 days were added on to his wrongful conviction. The question before the court today is, under the WICA, is Mr. Ricks allowed to be fully compensated for all of the time that he spent wrongfully in prison, or is there a provision that allows the state of Michigan to have a set-off? Now, the statute at the core of this case is section 1755(4) of WICA, which states that a claimant is not allowed to get compensation for any time that they are in prison under a concurrent or consecutive sentence for another conviction. The state of Michigan and the lower courts interpreted this provision to apply to the 4 years and 118 days that Mr. Ricks was imprisoned based on the triggering of the parole violation. However, this interpretation has a critical flaw, and that is that the October 13, 1992 judgment of sentence that is at the core of this case has been vacated in total. This judgment of sentence is the only judgment of sentence that contains a consecutive sentence applicable to the time that Mr. Ricks was wrongfully imprisoned. So that is the time that the state of Michigan is claiming that they are entitled to a set-off for. But because this judgment of sentence has been vacated, section 1755(4) is not implicated because there is no concurrent or consecutive sentence applicable to another conviction. Everything has been vacated. And all of the time that Mr. Ricks was wrongfully imprisoned is entitled to compensation, including the 4 years and 118 days that were triggered by the parole violation. I think my argument is pretty much that simple and straightforward. I'm open to any questions from the court now.
Thanks, Ms. Patel. Justice Viviano.
No questions, counsel. Thank you.
Justice Bernstein.
No questions.
Justice Clement.
No questions right now.
Justice Cavanagh.
I don't have any right now.
Justice Welch.
No questions.
Justice Zahra.
No questions, thank you.
Ms. Patel, you want to use some more of your time or reserve? Up to you.
I have a couple of other points that I would like to make, and then I'll reserve the remainder of my time for rebuttal. First, I think that there was this argument that could possibly be made that does my interpretation of this section of WICA make it nugatory? If I think that was an issue that was raised in the Court of Appeal, certainly it was at oral argument, and I'd like to address it with the court now. And it's not. I think that the particular circumstances of Mr. Ricks's case, where his parole was violated solely because of the wrongful conviction, make this case unique and make this case just for him to receive compensation for all of the time that he spent wrongfully convicted. Now, I don't think that the legislature ever intended for Section 1755-4 to be applied to circumstances like Mr. Ricks's, where the parole was violated. And I think you can find support for that in the language of the statute itself, which talks about a concurrent or consecutive sentence. Now, by Michigan statute, anytime a parolee is convicted of a subsequent crime and a parole revocation is triggered as a result, that sentence necessarily has to run consecutive to any other sentence that's applied. If the legislature meant for this section to apply to circumstances like Mr. Ricks, maybe they wouldn't have put concurrent or consecutive. Like there's no way for Mr. Ricks's conviction to have run concurrently because statute provides that it has to run consecutive to any new conviction. So I think that this statute was meant to apply to situations where, if somebody was convicted of crime A and crime B and later exonerated for crime A, but not for crime B, you would still have a concurrent or consecutive sentence running at that time, but not necessarily in the situation here where we have the only reason we have a consecutive sentence that applied in any case was because of the wrongful conviction. And other than that, I will reserve the rest of my time for rebuttal.
Thank you, Ms. Patel. Mr. Restuccia.
May it please the court, Eric Restuccia from the Attorney General's Office, appearing on behalf of the state. I have 2 points I'd like to make this morning, but I want to start with a caveat. And that is, we in the Department of Attorney General view these cases a little differently. We serve more as stewards of the law, at least we think of ourselves as that, rather than really pure advocates on behalf of a client. And anyone who's worked with this statute knows that the legislature has not compensated everyone who might be deserving, nor for everything for which one might be deserving. So with that, I have 2 points. And the first is that the first 4 years, 118 days that Mr. Ricks spent in prison was ultimately based on his 1987 conviction for armed robbery. That conviction was never set aside. That was the source of the Department of Corrections' jurisdiction over him. The statute does not remedy the wrongful imposition of additional time on a prior valid conviction. It's not a wrongful parole violation statute. In the same way that if a different circumstance in which you had an offender who had a wrongful conviction and then a valid conviction, and the valid conviction habitualized and relied on the invalid conviction to enhance his sentence, there is no compensation, there's no remedy. Well, the same is here. The second point is the statute is unambiguous. Compensation is denied for a plaintiff who is imprisoned under a concurrent or consecutive sentence for another conviction. And that's exactly what happened. He had a 1987 conviction for armed robbery. So consequently, he's not entitled to relief under the statute. And if he's looking for a remedy, the remedy has to come from the legislature. I've also kind of identified the Powell's case, another case we worked on. And I know the amicus identified Johnson. If the court doesn't agree with the state's position, we're just looking for clear guidelines. I think this is the right construction. I think it's the 1755-4 is unambiguous. But if the court's going to create a different rule, it just has to be a rule that the state can apply consistently. And with that, I'm ready for questions, Your Honor.
Thank you. Justice Viviano.
No questions. Thank you, Mr. Restuccia.
Justice Bernstein.
Hey, good morning, Mr. Restuccia. I have to say, I'm a huge fan of yours, and I always love it when you come to our court. I have to take a little bit of an issue, but and unfortunately, I have to take a little bit of an issue, and I'm not going to take too much of your time, but I understand the crux of your argument, but the common sense perspective of it would indicate that the whole reason that he spent the extra 4 years in prison was because of a wrongful conviction. Your argument that basically this arose out of a past crime, I have trouble with it, and I'm just going to let you argue back with me, but I have trouble with that because my understanding of this is that he wouldn't have had the parole violation but for the wrongful conviction.
I think you're exactly right, Your Honor. And in a way, it has to do with line drawing, and we're trying to just follow the lines that the legislature has drawn. Like, for example, if you look at the way the statute's created, it doesn't provide relief for people who are wrongfully convicted and go to jail. I mean, the way the funding scheme says it has to do with calculations based on prison time. Now, why wouldn't someone who got convicted and got a lesser sentence, I served a year in jail, why don't I get relief? Well, in our office, we say you don't get relief because the statute doesn't provide for it. The same thing is, let's say I was convicted and ultimately the Court of Appeals said there was insufficient evidence. Well, that's not a basis for relief, that you're not going to get any relief under this statute. That's not the way the statute operates. Well, by the same token, the legislature here has said under 1755-4 that we're not going to provide relief for someone for a parole violation additional time. Now, why? Now, I guess I could see that maybe the idea is if someone is getting time on a conviction in the same way that they don't want people to get relief if they have another conviction that arises out of the same transaction. There could be a policy basis for it, although, it may well be the case, as Ms. Patel has argued, that they didn't contemplate it. I don't know, but I think there is a policy justification that would draw the line there, because the 4 years that he served was for the armed robbery. He got 4 to 10, and then he served 4 additional years. Now, he wouldn't have served that time, I grant you, but for this parole violation. Now, I've raised this other issue about the fact he was involved in drug activity, and maybe they would have violated him anyway. But I think that's a really not something the court needs to reach, because the point is the statute has drawn this line, and we just feel compelled, whether commonsensical or not, to apply it. And if the court wants to draw the line differently, just make it clear to us, and we'll follow that.
Okay. Thank you, counsel.
Justice Clement.
Thank you. Can you elaborate on the example that you gave about the analogy that you gave on a habitual offender and how that would work? Because I find that maybe more compelling, because I share Justice Bernstein's general concerns of this really just doesn't seem fair. But I'd like to hear a little bit more on your thoughts on the habitual offender piece.
All right, sure. So let's say offender is wrongfully convicted of an initial crime, and nobody knows it, and the person serves a sentence, is released, is back out in the community, and then is rightfully convicted of, let's say, assault with intent to do great bodily harm, less than murder, a 10-year felony, and would ordinarily be given a 5 to 10-year sentence, but they're being habitualized based on the wrongful conviction. So now they have a prior conviction. Now they shouldn't have that conviction, but they do. And so the way 769.10 operates is it's a 50% enhancement. So instead of getting 5 to 10, now I'm going to get 7.5 to 15. Now, when I'm then exonerated for that first conviction, I can't come back and say, hey, and wait, by the way, I served 2.5 years more on that second conviction, which I would never have served, but for this wrongful conviction. It's entirely true, but the statute doesn't provide relief or compensation for additional time served on a rightful conviction. And I think I want to make one further point about some of the anomalies created for us about this. I mean, here he had served armed robbery at 4 to 10, and they got this very long sentence, 30 to 60 on the second-degree murder plus 2 on something he hadn't done. He was totally innocent of that crime. But if you turn these numbers around a little, let's say his rightful conviction had been one for which he got a 20 to 30-year sentence. And then he was wrongfully convicted of felonious assault and got 1 to 4. So let's say he served his 20. He has 10 years still left on his tail, as the language would be in the trade. He has 10 years left remaining on the first conviction. If he's given that 1 to 4, the Department of Corrections can hold him up to another, total of 14 years. So if he gets a 1 to 4, and let's say the reason he's held after he's violated and gets the 1 to 4, he wants to serve 1. He serves another 10 because he's a terrible prisoner. And he's not paroled because he's eligible for parole right after he serves the 1. And so he serves 10 years, 10 more years. And he comes back and says to the state, I want 10 years worth of payments for my felonious assault for which I got that 1 to 4 because I served 10 more years. And our answer would be, the statute doesn't allow it. That time, time was spent because it was attributed to, it is the jurisdiction of the Department of Corrections is based on the first conviction, which was valid. In other words, if you're getting time on a valid conviction, whether you would have served that time or not, or been given that sentence, the statute doesn't, and its plain meaning to me, provide for relief.
Okay, well, you just teed up my second question, which is if the plain language is clear and unambiguous, why do we have the situation of Justly Johnson?
All right, so for Johnson, let me give it the kind of the factual background of that, because I don't think it's fully laid out. In fact, I had meant to do the brief in opposition, and I forgot, and then I didn't put it in this brief, so I really appreciate the amicus identifying it, because Powell's and Johnson, this is kind of and there's lots of interesting cases that we encounter, and so we want clear rules. So for Johnson, he had committed a drug crime, got lifetime probation. And then while he was on probation, he picked up this wrongful murder case. And then, how the circuit court does, they have the probation violation run along with the murder case, and ultimately he's convicted of first-degree murder. He's given a life sentence. The judge finds him in violation of his probation and then gives him a 1 to 20-year sentence. That happens in 2000. In 2018, he's exonerated. So all the time he served, 18 years, he's gotten, that has been on the drug case. They're running concurrent. It's still different in this case because this case is a consecutive, a stack case. That's a concurrent sentence. But he's still not entitled to relief on its appearance because he had this valid drug conviction. Well, in 2019, the drug conviction is vacated. So there's no longer a valid prior conviction from which this time could run concurrent. So the conclusion of our office is if there's no prior valid conviction, unlike Mr. Ricks, who has a 1987 armed robbery conviction, which remains valid, he received that time and it was based on that. I mean, that was the jurisdiction of the Department of Corrections was based on that. For Mr. Johnson, he has no other conviction now. So all the time he served was only left with this wrongful conviction. That was the way we reached this conclusion. So it seems like, the other cases, Powell's we have out there where he never got his parole date. He was convicted in, not to give you all these fact patterns or these cases. They're not fact patterns. I think of like an appellate attorney. These are real people. And let me just say this before I say anything further. Sometimes you get so embedded in the law, you miss the big picture. It's obviously a tragedy. It's a tragic thing that Mr. Ricks served 24 years in prison for a crime he didn't commit. And, I'm like anyone else. I don't want that to happen. That's the prosecutor's worst nightmare. Anyway, so talking about Mr. Powell, who got no relief, he was convicted of great bodily harm in 2007. He got an 8 to 12 year sentence. So he would have been eligible for parole in 2015. But he was wrongfully convicted in 2008 of murder for events that occurred prior. He wasn't involved, but he was wrongfully convicted. He was given a 45-year sentence. So they took his 2015 earliest release date and they pushed it out to 2060. So he never got his parole date. Now, 80% of offenders are released on their earliest release date. We know that. So, Powell's very likely would have been released on 2015, but he served through, and he never got that parole opportunity date, and he was released in 2019. He wanted the 4 years after the minimum he had served. Well, the answer is the statute doesn't allow for it. So we're just trying to apply the statute. So, I understand the fairness arguments but in a way, if we're not going to follow the statutory language, we need a new rule that's going to be clear and easy for us to follow.
Thank you.
Justice Cavanagh?
Yeah, a couple questions. The first one is just to clarify, and I think you have here today, you have said that, which I think makes sense, is that he was serving, or your position is a consecutive sentence. In your brief, it mentions concurrent. I just want to make sure that we're talking about the same thing.
Yes,
right?
In fact, I apologize for that.
No, I didn't mean to call it out. I just wanted to make sure that we're thinking about this the right way.
Right,
okay.
So stacking, right, exactly.
So applying the language of the statute, this subsection 4 that says he was imprisoned under a concurrent or consecutive sentence for another conviction, why is it not that those 4 years Mr. Ricks was serving for a parole violation under a separate statute, which is not a concurrent or consecutive sentence for another conviction? That other conviction provided the number, correct, but he was imprisoned because of a parole violation, not because of a consecutive sentence for another conviction.
Well, it's by operation of law that it's treated by law as a continuation of his original sentence. So you're right, it's a parole violation. But 791-238 says a prisoner violating the provisions of his parole is liable when arrested to serve out the unexpired portion of his or her maximum imprisonment. So by law, that sentence goes back to his original conviction. So in a way, when I read this, I'm just trying to apply this in a kind of a wooden way without thinking about the broader context of considerations of fairness and policy and things like that. I know that parole violation time by law is attributed to his original conviction, and that original conviction remains valid. So if I'm just trying to apply this, now it may be that they had in mind the circumstance that Ms. Patel addressed. You could have a consecutive sentence that would arise where it would be clear that the legislature wouldn't want you to get the relief. You commit crime A, you commit crime B, different time periods. You're sentenced at the same time. Let's say it's home invasion. That's permissively consecutive, and the judge is angry, makes it stacked. The answer is, well, it's clear that if you're serving on a valid conviction first, then you wouldn't get relief. Nobody would dispute that. So I agree that it can be given effect, and it doesn't render it nugatory, but I just don't see how you draw that distinction, or you say it's not going to apply here because we don't think the legislature wanted it to, when it didn't really tell us.
It is the time served for violation of parole, is that always served prior to the time for the new conviction?
Yeah, and that's what, in fact, that was the thing I failed to cite, and Ms. Patel exactly had it right, which is It's the 768.782. And I'll read it just so you have it handy. If a person is convicted and sentenced to a term of imprisonment for a felony committed while the person was on parole from a sentence for a previous sentence, the term of imprisonment imposed for the latter offense shall begin to run at the expiration of the remaining portion of the term of imprisonment imposed. So you serve your first sentence first, and then your second sentence second. And there's a further, overlay to that, because the Michigan Supreme Court, and this is how the corrections does, is they take your minimums and they stack them, and they take your maximums and they stack them for the parole violators. And that's Wayne County versus DOC 451 Mich 569. So as a matter of mechanics, they take the minimums and add them, and they take the maximums and add them. So really, he had like 4 left, I think 4 or 5 left on his maximum for his first sentence, but he had no minimum to serve. So really, when he got reconvicted wrongly, they would have given him 30 on the minimum, and they would have added for his max the 60 plus the max he had remaining, which was 4 or 5.
Okay, thank you.
Justice Welch.
No questions.
Mr. Restuccia, let me go back to the question Justice Cavanagh was asking. And I think you're about Justice Johnson. He, just like Mr. Ricks, had to serve out the remainder of his prior sentence before he started serving the sentence for his wrongful murder conviction. But I'm not actually, I agree with you. You just need clear rules, A, and, there are lots of reasons why the legislature has to decide where to cut off who's compensated and who's not. So people who serve time in jail, that was obviously a decision the legislature made, and lots of other ones. But the statute says 2 things about calculating compensation that I think are relevant here. The first is that a claimant gets $50,000 for each year from the date the plaintiff was imprisoned until the date he was released. I think we all agree about the date he was imprisoned and the date he was released. That's not that hard. It's the carve out. Compensation may not be awarded under subsection 2 for any time during which the plaintiff was imprisoned under a concurrent or a consecutive sentence for another conviction. So in this case, as Justice Cavanagh pointed out, he did not serve the time that he was imprisoned. He did not serve a concurrent sentence. He served first the remaining term on his whatever the previous, was it a drug case, and then the wrongful sentence. And that previous time was not consecutive. It's sort of, I know this isn't a term that anybody uses in sentencing, but he served an antecedent sentence. So why isn't the plain language of the WICA statute drafted exactly to allow someone like Mr. Ricks and Mr. Johnson, who have to serve a previous sentence out only because of a wrongful conviction? Why doesn't the plain language of the statute actually include that?
Well, if I'm trying to follow you, I understand the policy thought on it, but I'm just trying to.
No, it's not a policy question. It's
I know. I'm trying to understand, though, the language. If we say, well, all right, so was plaintiff not imprisoned under a consecutive sentence for another conviction? I mean, the law says
he's not to be compensated if he's imprisoned under a consecutive sentence for another conviction. The sentence he served to finish out his parole time, he did not serve consecutively to the wrongful sentence.
Well, right? let me step back then, because in a way, if you think about its core application.
But wait, you want to step back and talk policy? I thought you said you.
No. I'm just thinking that because if that's right, then I don't understand when it would ever have application. I mean, it seems like it runs.
When you do too. Come on, there are lots of times where somebody racks up a series of charges, right? And maybe ends up, convicted of all of them, and one of them maybe wrongfully. Too bad, so sad. You're out of luck per the statute, right? Not only that, somebody is at the scene of a crime and is maybe wrongfully convicted of one offense, but not of some others, right? They're partially culpable. Out of luck. There's lots of ways. I agree entirely. You can have that's the point I had made earlier, that you can have 2 different offense dates because you can't get out of the same transaction. But you can have different transaction dates be combined for sentencing. You end up with a consecutive sentence because they've been combined for sentencing. Sometimes you don't want to have your sentencing at the same time because otherwise you get concurrent. But if they're tethered together, then you get consecutive. I know that sometimes you'll join files for that very reason. These prosecutors will. And too bad, so sad, that guy's out of luck.
I know, I get it. But I'm trying to figure out what this means then here, because it seems like when it says for another conviction, so you're innocent of one and you're guilty of another. and the one for which you're guilty, if it's consecutive to the one for which you're actually guilty, you don't get relief.
It doesn't say anything about innocent or guilty. It doesn't say anything about innocent or guilty. It just says.
True. I'm just, the question is it's obviously talking about not the conviction that was the basis of the exoneration, right? So
Right,
when it
that's
says
right.
another conviction, we're talking about another case. And so we have another case. And so the other case here is the armed robbery, because the 1987, that was the underlying basis for the parole violation. So when it says was imprisoned for another conviction, he's being imprisoned by law for the armed robbery. That 4 years he got was punishment for the armed robbery, not for the murder. Now, obviously, the only reason he had to serve that was because of the wrongful conviction and the parole violation that arose from it. But I'm trying to hear the words. Maybe I'm so stuck in my own legal theory that I can't understand how this means something different than that the other conviction that refers to the armed robbery.
As you said, by operation of law, 768-782, he had to serve that parole tail first. He had to finish it before he could start serving the wrongful. Same for Jussie Johnson, exact same case, right?
Well, it's a little different. Johnson actually was concurrent because it was probation. But even so, the points are the same.
You know, that's not correct. I'm correcting you. That's not correct. Jussie Johnson actually served it. Sorry, I'm just correcting the record.
All right, no, sure, that's fine. The parole board told us differently, but maybe I misunderstood, but that's fine.
So if the statute says you can't get reimbursed for time that you served concurrently or consecutively for another conviction, and in this one little hypothetical where someone's only violated because of a new wrongful conviction, they're forced to serve it first, it's not concurrent or consecutive. That's all. It's just a plain language understanding of the statute that I was wondering if the legislature just actually figured out how to make sure that the person who is violated and therefore has to serve the tail of a parole sentence in an antecedent way and figured out a way to carve them out. It seemed to me the plain language maybe did that. I didn't know.
Well, maybe I'm just being obtuse. I still don't understand how the imprisoned for another conviction doesn't refer to the.
It does. It's just not served consecutively or concurrently. That's all I'm asking.
Oh, but so it's not consecutive because it was based on a wrongful conviction.
No, because he had to serve it first. Because per 768-7A2, he serves that term first.
Well, if I'm talking to like when I was talking to the parole board people or the corrections people, they would right now say, well, that's the very thing that lets us know that it's consecutive, that's what makes it consecutive, that 7A2 is essentially the consecutive sentencing statute. It has to be consecutive.
Which conviction was which one did he serve after this prison time for?
Murder 2.
Right. That's all I'm saying. Okay. I think I've exhausted. I've used up all your time. Let me
I apologize. My answers weren't responsive. I tried to be, but I don't think I fully understood your theory, but that's okay.
Justice Zahra.
Mr. Restuccia, I too am a very big fan of yours, and I understood the argument to be tragedies happen at times, and sometimes people are wrongfully convicted, and but for the government waiving its sovereign immunity, this tragedy would go without any repair, without any compensation whatsoever. And the government has decided to, in limited circumstances, provide a remedy for this tragedy. They came up out of thin air with the number of $50,000 a year. Is it worth $50,000 a year for you to be incarcerated? It's not to me, but that's the number they came up with. And they came up with parameters as to when they're willing to waive their immunity. Fair enough?
Yep.
And one of the things they say when we're waiving the immunity is that if you are serving time on a prior conviction, you're not entitled to any remedy for that service of time, even though it's there because of the wrongful conviction. Am I still on the same page with you?
Yes, you are.
And as I understand it, that's your argument, that it's a tragedy. The government gets to pick the government gets to pick when and how much and when and how you'll be compensated. And in this circumstance, because there was a prior 1987 conviction that, as a result of the wrongful conviction, required more time to be served, the statute does not provide a remedy. Fair enough?
I think that's exactly how I see it.
Okay, I'm a huge fan. I understood this. And then as you stop speaking, you say, if the court is to create a different rule, it must be one that can be applied consistently. Well, what do you have in mind?
Well,
what is that different rule that we can apply consistently? You have something in mind there?
I'm not advocating for a different rule. I'm just thinking about the practicalities, because in a way, it's kind of like my initial theme had been, we want to be stewards. We want to do the right thing. We want to apply the laws the legislature has given us. There's lots of cases that we're encountering. And so we're trying to apply these rules. In fact, the distinction we made in the Johnson case was that his prior conviction, which was the basis of his sentence, had been vacated. And because that conviction was vacated, there was no other conviction from which it could run either concurrent or consecutive, if the justice is right. I mean, we had been told, I think, but maybe wrong, whatever. It's the same answer, because whether it's concurrent or consecutive, the answer is the same. But the question of what would be a contrary rule, I'm not an advocate for a contrary rule, because in a way, I think, like, this reminds me of Chief Justice McCormack's concurrence in the denial of leave in Thomasik, that if the legislature wants to maybe revisit some of these rules, it can. Like, if you go to jail, you don't get relief. Sufficiency cases, you don't get relief. I mean, it's created parameters. So for us, I mean, I guess if the idea is, if you have a parole violation that's vacated, and this is what the Texas Supreme Court had done, right? It just provided relief. That I guess then the answer is that doesn't constitute somehow a consecutive or concurrent sentence. I mean, that doesn't really follow the language. But if the basis for the parole violation was something for which the conviction was wrongful, then you get compensation for that additional time. I mean, it still creates anomalies. I mean, the anomaly that I have in mind is this guy serving 20 to 30 and he gets 1 to 4 and ends up serving an 11. If the wrongful was 1 to 4, he gets 11 years for the wrongful. It doesn't make sense. That doesn't matter. We could apply that. That would be a consistent rule. We could apply it. And then Powell's, I guess, would be still left without relief, because ultimately he never got to his parole hearing. It was just extended. So if the idea is that we're going to provide compensation for anyone for any of the additional time that arises after the conviction, I guess we could apply that rule. I don't think that's what the statute says, but that's fine.
That would be my question. Is that consistent with the statute?
No, I don't think it is. I mean, I think we would be, I mean, in a way, that's kind of the point, is I think that the legislature's created the parameters and we're just trying to follow it.
Thank you.
Thank you, Mr. Restuccia. Ms. Patel, you have some rebuttal time.
Thank you, Your Honor. Really quickly, I take your point, Chief Justice McCormack, about the antecedent, the conviction being an antecedent conviction as opposed to concurrent or consecutive sentence. But I think I don't want to confuse issues in terms of with the equities versus a statutory argument. I mean, everyone can agree that it was inequitable and unjust for Mr. Ricks to have served almost 25 years imprisoned, wrongfully imprisoned. But our argument here is a statutory construction argument. And this statute provides that, that subsection 4 provides that only the state is only entitled to a set off for time that a plaintiff is imprisoned under a concurrent or consecutive sentence. Now, there's another statute, it's MCL 769.1H, which defines a consecutive or concurrent sentence. And that statute states that a concurrent or consecutive sentence has to be set forth in a judgment of sentence. And I think my argument here today boils down to the fact that we don't have a valid judgment of sentence that gave the MDOC any jurisdiction over Mr. Ricks after the 1992 judgment of sentence was vacated. That is the only sentence, that is the only judgment that contained the so-called consecutive sentence, we're going to call it. And it called it out, it named that statute. It said, citing to MCL 768.7A2, it set forth that Mr. Ricks had to serve out the remainder of the terms of the prior conviction before the new sentence started. So I think there's no question that all of the time that he spent in prison was due to this wrongful conviction. And the authority, the legal authority, stemmed from this 1992 judgment of sentence, which has now been vacated. So I don't think that there is a valid consecutive or concurrent sentence at issue in this case anymore, because that judgment has been vacated. And as a result, I don't think 1755-4 has any application in this case. Mr. Ricks is entitled to compensation for all of the time that he was wrongfully imprisoned, including the 4 years and 118 days triggered by the parole violation. The court has any questions?
Thank you. Let's see. Does anybody have additional questions for Ms. Patel?
I have one, and Ms. Patel, I was wondering if you could give us your thoughts on this. Do you think that in our decision in Sanford that we introduced the purpose of the statute, that, you know, compensation for wrongful incarceration, and we introduced that purpose as an interpretive tool when it comes to interpreting WICA, you know, even if there may be a mechanical reading of the statute that would suggest otherwise. And if that's the case, if that is how we interpret WICA through the purpose of it, I think everybody agrees that the 4 years, regardless of what it is, was wrongful, that he would not have served that but for the wrongful conviction. I guess what's your position with regard to how Sanford guides the decision in this case?
I absolutely agree, Your Honor. Sanford did a very thorough analysis of what wrongful meant under this statute. And again, in the circumstances of this case, I don't think there's there's no dispute that Mr. Ricks's conviction was wrongful. And under that application and under the purpose of WICA, I think he's entitled to compensation for that entire time.
Under the purpose. Okay, thank you very much.
Any additional questions for Ms.
Yeah, I
Patel?
got one follow-up.
Okay, excellent.
Thank you, Ms. Patel. So I want to go back to 1H. So are you indicating that the original sentence for armed robbery needed to state whether the sentence runs consecutively to or concurrently with any other sentence, or that the wrongful conviction could have indicated that? I'm just trying to understand under 1H, saying which conviction had to have that language.
Sure. Under 1H, it's definitely the wrongful conviction that had to have it, and it did have it. It specifies in there that under 768(7)(a)(2), the term of imprisonment imposed in this case shall begin to run at the expiration of the remaining portion of the term of imprisonment imposed in the prior case. So that language in the second judgment of sentence for the wrongful conviction is what I am interpreting to be the consecutive sentence, because for the first conviction, there was only the one conviction at issue. It couldn't run consecutively or concurrently with anything at that point. You only have the second conviction and this issue of what is it running concurrent or consecutive to when you get to the 1992 wrongful conviction. And this judgment of sentence, it does that. It sets forth what Justice McCormack identified as the antecedent conviction or the consecutive conviction, but it's set forth in this judgment of sentence. And my argument is that because this judgment of sentence has been vacated, there is no judgment of sentence that sets forth a consecutive or concurrent sentence that applies to Mr. Ricks's wrongful conviction.
Okay, I think that flushes out what the chief was driving at, and I think that helps give context to the consecutive and concurrent and how that plays into this. So thank you for that. I appreciate it.
Any additional questions for Ms. Patel? Thank you both. The case will be submitted.